Hi, I'm Cynthia Cruz, and I'm with Steve Bohm today to talk a little bit about some legislative developments in connection with BDCs. Just to give a little bit about the development of the industry, can you talk a little bit about that, Steve?
Yes, the industry has really grown substantially in the last 20 years. Before 2003, there were a couple of large internally managed BDCs. 2004, Apollo came in, $930 million IPO, shook things up. Shortly thereafter, another dozen or so filed, like Apollo, as externally managed BDCs, and that's been the industry trend. Since then, in 2008, the idea of a non-traded BDC was introduced by Franklin Square, and in 2011, TPG came out with the first private BDC.
So, and you and I have been doing this since there was less than a handful. How many are there today?
There are about 92 BDCs today, broken out among those three categories.
And so what happened on March 23rd that shook up the industry a little bit?
March 23rd, Congress enacted the Small Business Credit Availability Act, which substantially changed the world for BDCs in two ways. First, it changed the maximum leverage that a BDC could incur, reducing the asset coverage from 200% to 150%, meaning BDCs can now lever 2 to 1. Secondly, there was important securities offering reform enacted, which put BDCs on an equal footing with other public companies in terms of their reporting obligations.
So let's talk about the leverage increase. This is something that I believe people have been looking at for over 10 years, and the BDCs have been actively working with Congress to try and make this change.
Yes, this has been something that BDCs have sought for a long time, and it's become increasingly important as the industry is tending toward moving up balance sheet where yields can be increased through the use of leverage. This has been something that's been important and is gratefully received by the industry.
And so the change is to go from 1 to 1 to 2 to 1. What's the corporate process? Is it a board vote? Is it a shareholder vote?
Under the Act, it can be done either way. If the board approves the change, it cannot go into effect for 1 year. If it's put to shareholders and there's a shareholder approval by a 1940 Act majority, then it can be enacted immediately.
And the thought process was to allow effectively the shareholders to get out if they didn't want to be in a vehicle that had that type of leverage. So that's what the waiting period's all about, right?
That's right. And there's an equivalent provision which gets the same result for non-traded BDCs. There, the company has to offer up to 25% liquidity 4 times in a year before the greater leverage permissibility can be put in place.
Right, and when a company's looking at, a BDC's looking at trying to take advantage of this, they need to be looking at the various stakeholders, the shareholders, whether they could get a vote through, their lenders, the SEC, what the SEC is going to say. I mean, there's a lot of different factors they need to be considering.
There are a lot of unknowns, and I think a very important one are the consents that may be necessary in credit facilities for BDCs, which have important restrictions on the ability of BDCs to exceed 200% asset coverage.
Right. But this goes into effect immediately, unlike the reform rules we were talking about. Those have been in place for almost 15 years for other operating companies, but now BDCs can now take advantage of this, but the SEC has to write rules for that, right?
That's right. It's not immediate, but it's very salutary. BDCs will be able to update their registration statements by incorporating by reference from other public filings instead of having to re-put all the same data in and having the SEC staff review it before a registration statement goes stale.
Right, and also BDCs will be able to basically communicate more effectively. They won't necessarily have to be producing so much paper as far as delivering prospectuses and that type of thing. So there's a lot of intricate rules that will be very helpful for BDCs, and it'll make it more efficient and cost effective for them.
That's right, and again, this is something that was never controversial. It was just a question of the vehicle through which this would get enacted. The staff has never fundamentally opposed it. This was a good time to get it put into place.
Right, and actually, just so everybody knows how much of a surprise, which is the way I thought that this would happen, it was out of a 2,000-page bill, it was page 1999. Thank you for joining us. For more information on the Small Business Credit Availability Act and other bottom line videos, please access eversheds-sutherland.com.